Hello and welcome to Bar 10 Test Prep, where we help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so that you can be notified every time we upload new content. Question number 1. City enacted an ordinance banning from its public sidewalks all machines dispensing publications consisting wholly of commercial advertisements. The ordinance was enacted because of a concern about the adverse aesthetic effects of litter from publications distributed on public sidewalks and streets. However, City continued to allow machines dispensing other types of publications on the public sidewalks. As a result of the City ordinance, 30 out of the 300 sidewalk machines that were dispensing publications in the City were removed. Is this City ordinance constitutional? A. Yes, because the regulations of commercial speech are subject only to the requirement that they be rationally related to a legitimate state goal, and that requirement is satisfied here. B. Yes, because City has a compelling interest in protecting the aesthetics of the sidewalks and street, and as such, a ban is necessary to vindicate this interest. C. No, because it does not constitute the least restrictive means with which to protect the aesthetics of city sidewalks and streets. Or D. No, because there is not a reasonable fit between the legitimate interests of the city in preserving the aesthetics of its sidewalks and streets and the means it chose to advance that interest. You have 10 seconds to choose the correct answer. If you chose option D, you'd be correct. No, because there is not a reasonable fit between the legitimate interest of city in preserving the aesthetics of its sidewalks and streets and the means it chose to advance that interest. Generally, truthful commercial speech may only be regulated if the regulations satisfy intermediate scrutiny, which requires 1. That the regulation serves a substantial government purpose, 2. Directly advances that interest, and 3. is narrowly tailored to that interest. In this state and in this fact pattern, the city is attempting to regulate truthful commercial speech by banning from public sidewalks all machines dispensing publications consisting wholly of commercial advertisements. The reason for this ordinance was a concern about the adverse aesthetics effects from litter and publications being distributed on the sidewalks and streets. The problem with the city's action is that the city continued to allow other machines, which in essence were 90% of the machines available. So the fact here that we have 30 out of 300 machines, meaning 10% of the purported problem which is being addressed, ultimately would seem as if more the publications are being singled out rather than the overarching problem of the litter is what's being addressed. Let's look at options A, B, and C. A. Because the regulations of commercial speech are subject only to the requirements that they be rationally related to a legitimate state goal. As we just found out from answer D, this is not rational basis, this is intermediate scrutiny. So that would not be correct because that's not the correct level of scrutiny to be used. B, yes, because city has a compelling interest in protecting the aesthetics of the sidewalks and streets, and as such, a ban is necessary to vindicate this interest. Again, if we look at the numbers, the mere fact that we're only addressing 10% of the problem, B would not make much logical sense given that fact. C, no, because it does not constitute the least restrictive means with which to protect the aesthetics of city sidewalks and streets. While that does not seem to be directly applicable in that it isn't the least restrictive means, it's actually not even a means that addresses the underlying problem at all, because again, in looking at the numbers, we're only addressing 10% of the problem. As such, A, B, and C are not accurately or correctly worded answers, so D would be the correct answer. Let's give question number 2 a try. Plaintiff's estate sued defendant Stores, claiming that Guard, one of the defendant's security personnel, wrongfully shot and killed plaintiff when plaintiff fled after being accused of shoplifting. Guard was convicted of manslaughter for killing plaintiff. At his criminal trial, Guard, who was no longer working for the defendant, testified that defendant's security director had instructed him to stop shoplifters at all costs. Because Guard's criminal conviction is on appeal, he refuses to testify at the civil trial. Plaintiff's estate then offers an authenticated transcript of Guard's criminal trial testimony concerning the instructions of defendant's security director. The evidence is A, admissible as a statement of an agent of a party opponent. B, admissible because the instruction from the security director is not hearsay. C, admissible, although hearsay, as former testimony. Or D, inadmissible because it is hearsay, not within any exception. You have 10 seconds to consider your choices. The correct answer here is D. If you chose D, you'd be correct. It's inadmissible because it's hearsay, not within any exception. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in the statement. The hearsay exceptions are admission of a party opponent, vicarious party admissions, and prior statements by witnesses. The hearsay exceptions are excited utterances, present sense impressions, present state of mind, statements of past or present mental or physical condition made for medical diagnosis or treatment, business records exception, public records exception, and judgments of previous conviction. In this case, Guard, who was no longer working for defendant, testified at his criminal trial that defendant's security director had instructed him to stop all shoplifters at all costs. Since Guard is no longer working for the defendant, the hearsay exceptions of admissions of a party opponent and vicarious party admissions do not apply. Also, since Guard has refused to testify at the civil trial, the prior statements of witness exemption does not apply either. As such, since none of the hearsay exceptions or exemptions apply, this statement by Guard is inadmissible because it is hearsay, not within any exception. Let's move on to question number 3. Several years ago, Bart purchased Goldacre, financing a large part of the purchase price by a loan from Mort that was secured by a mortgage. Bart made the installment payments on the mortgage regularly until last year. Then Bart persuaded Pam to buy Goldacre, subject to the mortgage to Mort. They expressly agreed that Pam would not assume and agree to pay Bart's debt to Mort. Bart's mortgage to Mort contained a due-on-sale clause stating, if mortgagor transfers his or her interest without the written consent of mortgagee first obtained, then at mortgagee's option the entire principal balance of the debt secured by this mortgage shall become immediately due and payable. However, without seeking Mort's consent, Bart conveyed Goldacre to Pam, the deed stating in pertinent part, subject to a mortgage to Mort. Pam took possession of Goldacre and made several mortgage payments, which Mort accepted. Now, however, neither Pam nor Bart has made the last 3 mortgage payments. Mort has brought an appropriate action against Pam for the amount of the delinquent payments. In this action, judgment should be for A, Pam because she did not assume and agree to pay Bart's mortgage debt. B, Pam because she is not in privity of estate with Mort. C, Mort because Bart's deed to Pam violated the due-on-sale clause. Or D, Mort because Pam is in privity of estate with Mort. You have 10 seconds to choose the best option. If you chose option A, you'd be correct, Pam, because she did not assume and agree to pay Bart's mortgage debt. A buyer of a property who takes subject to a mortgage does not assume the mortgage, is not personally liable for the mortgage payments. However, if the mortgage goes unpaid, then the property is subject to foreclosure. Here, Pam bought Goldacre subject to the mortgage to Mort. However, Pam did not assume and agree to pay Bart's debt to Mort. This means Pam was not personally liable for the mortgage payments. The several mortgage payments she made did not create an obligation to make further payments. Thus, judgment should be for Pam, because she did not assume and agree to pay Bart's mortgage debt. Let's move on to question number 4. The police in City notified local gas station attendants that a woman known as Robber recently had committed armed robberies at 5 city gas stations. The police said that Robber was approximately 75 years old, had white hair, and drove a vintage, cream-colored Ford Thunderbird. Attendants were advised to call police if they saw her, but not to attempt to apprehend her. Armed robbery is a felony under state law. Traveler was passing through City on a cross-country journey. Traveler was a 75-year-old woman who had white hair and drove a vintage, cream-colored Ford Thunderbird. When Traveler drove into Owner's gas station, Owner thought Traveler must be the robber wanted by police. After checking the oil at Traveler's request, Owner falsely informed Traveler that she had a broken fan belt, that her car could not be driven without a new belt, that it would take him about an hour or so to replace it, and that she should stay in the office for consultation about the repair. Traveler was greatly annoyed that her journey was delayed, but she stayed in owner's office while she waited for her car. Owner telephoned the police, and within the hour, the police came and questioned Traveler. The police immediately determined that Traveler was not robber, and Traveler resumed her journey without further delay. In Traveler's action for false imprisonment against owner, Traveler will A. not prevail if owner reasonably believed that Traveler was the robber. B. not prevail because Traveler suffered no physical or mental harm. C. prevail if Traveler reasonably believed she could not leave owner's premises. D. prevail because owner lied to Traveler about the condition of the car. Take 10 seconds to choose the best option. If you chose option A, not prevail if owner reasonably believed that the Traveler was the robber, you'd be correct. False imprisonment is the intentional infliction of a confinement where the victim has knowledge of or is harmed by the confinement. Privilege of arrest is a defense to false imprisonment. Under the privilege of arrest defense, a private citizen may arrest another without warrant if 1. the private citizen has reasonable grounds to believe that a felony has been committed and that the suspect committed that felony, and 2. a felony was actually in fact committed. In this case, Traveler can make a prima facie case on false imprisonment because owner intended to confine Traveler at the gas station by keeping her car, and Traveler was aware of this confinement. Nevertheless, her action against owner will not prevail if the privilege of arrest defense is satisfied. Police had notified the owner that a string of armed robberies had occurred at gas stations by a woman named Robber driving a specific vehicle. Traveler matched the description of robber, and the two women drove the same model vehicle. Thus, owner had reasonable grounds to believe that a felony had been committed and that Traveler, in fact, was the one who committed those felonies. Therefore, if owner reasonably believed that Traveler was the robber, owner's privilege of arrest defense will succeed, and Traveler will not prevail in her false imprisonment claim. Now let's look at number 5. The legislature of State X is debating reforms in the law governing insanity. 2 reforms have been proposed. Proposal A would eliminate the insanity defense altogether. Proposal B would retain the defense but place on the defendant the burden of proving insanity by a preponderance of the evidence. Opponents of the reforms argue that the proposal would be unconstitutional under the Due Process Clause of the United States Constitution. Which of the proposed reforms would be unconstitutional? A. Both proposals. B. Neither proposal. C. Proposal A only. Or D. Proposal B only. Take 10 seconds and choose what you think is the best answer. If you chose B, you'd be correct. There is nothing under the Due Process Clause of the United States Constitution that would prohibit either of these reforms. The only constitutional issue that can arise under the due process of the U.S. Constitution would be relieving the prosecution of the burden to prove each and every element of a criminal offense beyond a reasonable doubt. Insanity is not an element of a criminal offense, but rather a defense. As such, neither of these proposed reforms would be unconstitutional. Question number 6. In a single writing, painter contracted with farmer to paint 3 identical barns on her rural estate for $2,000 each. The contract provided for farmer's payment of $6,000 upon painter's completion of the work on all 3 barns. Painter did not ask for any payment when the first barn was completely painted, but she demanded $4,000 after painting the second barn. For this question only, assume that farmer rightfully refused painter's demand for payment. If painter immediately terminates the contract without painting the third barn, what is painter entitled to recover from farmer? A. Nothing, because payment was expressly conditioned on completion of all 3 barns. B. Painter's expenditures plus anticipated profit in painting the first 2 barns, up to a maximum recovery of $4,000. C. The reasonable value of painter's services in painting the 2 barns, less farmer's damages, if any, for painter's failure to paint the third barn. And D, the amount that the combined value of the 2 painted barns has been increased by painter's work. Take 10 seconds and see if you can choose the best answer. If you chose option C, you'd be correct. When contract theory fails to produce a just result, quasi-contract is available as an equitable doctrine to prevent the unjust enrichment of one party. A quasi-contract arises when one party confers a benefit upon the other with a reasonable expectation that they will be receiving payment for the benefit that they conveyed. Unlike contract damages, however, the measures of damages under quasi-contract is restitution or the prevention of unjust enrichment, as opposed to damages. In this case, the painter-farmer contract provided for a farmer's payment of $6,000 upon the painter's completion of the work on all 3 barns. Painter breached the contract by terminating the contract without painting the 3rd barn. By failing to paint the 3rd barn, painter cannot recover anything under the painter-farmer contract. However, quasi-contract is available to prevent farmers' unjust enrichment from getting 2 barns painted without paying anything to the painter, and obviously for painter's time in painting those 2 barns. Under a quasi-contract, farmer would have to pay painter the reasonable value of painter services in painting the 2 barns. If farmer suffered any damages from painter's failure to paint the 3rd barn, then farmer's damages would have to be deducted from painter's recovery. Therefore, painter is entitled to recover the reasonable value of painter services in painting the 2 barns minus any damages to the farmer for the painter's failure to paint the 3rd barn.
Arrest and prosecution of all persons acquitted of a crime by a court or against whom criminal charges were filed and subsequently dropped or dismissed. The purpose of the statute is to protect those persons from further publicity or embarrassment relating to those state proceedings. However, the statute does not prohibit the publication of such information that is in the possession of private persons. A prominent businessman in Neosho City in Brunswick was arrested and charged with rape. Prior to trial, the prosecutor announced that new information indicated that the charges should be dropped. He then dropped the charges without further explanation, and the records relating thereto were closed to the public pursuant to the Brunswick statute. The Neosho City Times investigated to determine why the businessman was not prosecuted but was refused access to the closed official state records. To determine whether the law enforcement agencies involved were properly doing their duty, the Times filed suit against appropriate state officials to force opening of the records and to invalidate the statute on constitutional grounds. Which of the following would be most helpful to the state in defending the constitutionality of the statute? A, the fact that the statute treats in identical manner the arrest and prosecution records of all persons who have been acquitted of a crime by a court or against whom criminal charges were filed and subsequently dropped or dismissed. B, the argument that rights of the press are no greater than those of citizens generally. C, the fact that the statute only prohibits public access to these official state records and does not prohibit the publication of information they contain that is in the possession of private persons. Or D, the argument that the state may seal official records owned by the state on any basis its legislature chooses. Take 10 seconds and please choose the best answer. Correct answer is C. The fact that the statute does not prohibit public access to these official records to just anyone, and just blanketly does. The state may not impose liability for the accurate publication of information in the public record, but it may limit its own dissemination of information to the public. In this case, the state of Brunswick enacted a statute limiting its own dissemination of information to the public record. For example, the statute provides for the disclosure of the official state records of arrest and prosecution of all persons acquitted of a crime by a court or against whom criminal charges were filed and subsequently dropped or dismissed, but does not, in fact, prohibit the publication of information they contain that is in the possession of private persons. As such, this information will be most helpful to the state in defending the constitutionality of the statute.
Let's look at question number 8. Ms. Pence sued Duarte for shooting her husband from ambush. Ms. Pence offers to testify that the day before her husband was killed, He described to her a chance meeting with Duarte on the street in which Duarte said, "I'm going to blow your head off one of these days." The witness's testimony concerning her husband's statement is A, admissible to show Duarte's state of mind, B, admissible because Duarte's statement is that of a party opponent, C, inadmissible because it is improper evidence of a prior bad act, or D, inadmissible because it is hearsay not within any exception. Take 10 seconds and see if you can choose the best option. The best option is D, inadmissible because it is hearsay not within any exception. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in the statement. The hearsay exemptions are 1. Admissions of party opponents, 2. Vicarious party admissions, and 3. Prior statements by a witness. The hearsay exceptions are excited utterance, present sense impressions, present state of mind, statements of past or present mental or physical condition made for medical diagnoses or treatment, business records exception, public records exception, and judgment of previous conviction. Furthermore, hearsay included within hearsay is not excluded under the hearsay rule if each of the combined statements conforms to an exception to the hearsay rule provided under the federal rules of evidence. Here, Ms. Pence's testimony would be double hearsay. First, because Duarte's original statement was out of court. And second, because Mr. Pence's recounting of Duarte's original statement was also out of court. For Ms. Pence's statement to be admissible, one would need to find a hearsay exception to apply to each of these two levels of hearsay. Although Mr. Pence is unavailable since he's dead, the statement in question is not within any exception. While it's true that Duarte's statement by itself would be admissible under the admission of a party opponent exemption to hearsay, this analysis ignores the second level of hearsay, i.e. the husband's statement. So, as a result, given the double hearsay situation, we are faced with D being the most correct answer. The statement would be inadmissible because it is hearsay not within any exception. Question number 9. Corp, a corporation, owned Blackacre in fee simple, as the real estate records showed. Corp entered into a valid written contract to convey Blackacre to Barbara, an individual. At closing, Barbara paid the price in full and received an instrument in the proper form of a deed, signed by duly authorized corporate officers on behalf of Corp, purporting to convey Blackacre to Barbara. Barbara did not then record the deed or take possession of Blackacre. Next, George, who had no knowledge of the contract or the deed, obtained a substantial money judgment against Corp. Then Barbara recorded the deed from Corp. Thereafter, George properly filed the judgment against Corp. A statute of the jurisdiction provides, any judgment properly filed shall for 10 years from filing be a lien on the real property then owned or subsequently acquired by any person against whom the judgment is rendered. Afterward, Barbara entered into a valid written contract to convey Blackacre to Polly. Polly objected to Barbara's title and refused to close. The Recording Act of the jurisdiction provides, unless the same be recorded according to law, no conveyance or mortgage or real property shall be good against subsequent purchasers for value and without notice. Barbara brought an appropriate action to require Polly to complete the purchase contract. The court should decide for A, Polly, because George's judgment was obtained before Barbara recorded the deed from Corp. B, Polly, even though Corp's deed to Barbara prevented George's judgment from being a lien on Blackacre, George's filed judgment poses a threat of litigation. C, Barbara, because Barbara recorded her deed before George filed his judgment. Or D, Barbara, because Barbara received the deed from Corp before George filed his judgment. Take 10 seconds and choose the correct answer. If you chose D, Barbara, because Barbara received the deed from Corp before George filed his judgment, you'd be correct. The rule is that the recording system protects bona fide purchasers and mortgagees only. A bona fide purchaser is a subsequent purchaser who purchases the property for valuable consideration and without notice at the time of conveyance. Notice can be actual or constructive. In this case, Corp entered into a valid written contract to convey the Blackacre to Barbara. While Barbara did not immediately record this deed after closing, she did record the deed before George properly filed his money judgment against Corp. However, the recording statute of the jurisdiction is a notice statute. So a subsequent purchaser for value without notice of the prior interest will prevail, regardless of who recorded first. However, none of this is relevant because another statute of the jurisdiction also provides any judgment properly filed shall for 10 years from filing be a lien on the real property then owned or subsequently acquired by any person against whom the judgment is rendered. Since Corp had already conveyed Blackacre to Barbara, it was not then owned when George filed his judgment against Corp. As such, the court should decide for Barbara because Barbara was the owner of Blackacre when George filed his judgment against Corp. Now let's look at question number 10, our last question in this grouping. Powell, who was an asbestos insulation installer from 1955 to 1965, contracted asbestosis, a serious lung disorder, as a result of inhaling airborne asbestos particles on the job. The asbestos was manufactured and sold to Powell's employer by the Acme Asbestos Company. Because neither Acme nor anyone else discovered the risk of asbestos installers until 1966, Acme did not provide any warnings of the risk to installers until after that date. Powell brought an action against Acme based on strict liability and tort for failure to warn. The case is to be tried before a jury. The jurisdiction has not adopted a comparative fault rule in strict liability cases. In this action, an issue that is relevant to the case and is a question for the court to decide as a matter of law rather than for the jury to decide as a question of fact is whether a satisfactory, safer alternative insulation material exists under today's technology, b, the defendant should be held to the standard of a prudent manufacturer who knew of the risks, regardless of whether the risks were reasonably discoverable before 1966, c, the defendant should reasonably have known of the risk of asbestos insulation materials before 1966, even though no one else had discovered the risks, or D, the asbestos insulation materials to which the plaintiff was exposed were inherently dangerous. Take 10 seconds and choose what you think to be the best answer. If you chose B, you'd be correct. The defendant should be held to the standard of a prudent manufacturer who knew of the risks, regardless of whether the risks were reasonably discoverable before 1966. The rule is that even for properly manufactured and designed products, a manufacturer has a duty to warn if the product has non-obvious risks. This duty is breached if the manufacturer fails to give adequate warnings or instructions regarding the product's correct usage. In this case, Acme manufactured and sold asbestos to Powell's employer, but did not provide any warnings of the risk to installers until after the risk to asbestos installers were discovered in 1966. So the issue here is Acme's failure to warn of undiscovered risks. While it is true that neither Acme nor anyone else discovered the risks of asbestos installers until 1966, it is possible that Acme was aware of the possibility of risks prior to this date and should have provided warnings of these risks. As such, the judge must decide as a matter of law whether the defendant should be held to a standard of a prudent manufacturer who knew of the risks, regardless of whether the risks were reasonably discoverable before 1966. Again, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Please remember to like, subscribe, and ring the notification bell so that you can be updated every time we upload new content.